SJC-12810, Fulvio Joseph Gentili v. Town of Sturbridge.
Ms. Capobianco, good afternoon.
Good afternoon, Your Honors. Thank you. May it please the Court, my name is Attorney Teresa Capobianco. I represent the plaintiff appellants, the trustees of the Renato Gentili Trust. We're asking this Court to apply existing inverse condemnation and constitutional law principles to compensate the trust for land that was rendered unusable because of the town's actions. The Constitution provides that the government shall not take the property of its citizens without just compensation. And a corollary to that principle is that the government cannot unduly burden one landowner for a public purpose which benefits the whole without just compensation to the landowner. But when it does so, the Fifth Amendment, Article 10 of the Declaration of Rights and Chapter 79 provide a remedy to the landowner to recover the reasonable compensation due for the permanent physical intrusion made for the public benefit.
Now, you don't argue in any event that there was not a prescriptive easement that was established in the first lawsuit. You didn't take an appeal from that, so you're agreeing that there was a prescriptive easement.
We're not contesting the land court decision.
Okay, fine.
In this case, the Superior Court found that it was the trust's failure to assert its property rights and not any state action which caused the trust to lose its property rights. The Superior Court relied upon Texaco versus Short, but that reliance is misplaced as Texaco is not controlling in this case. Texaco involved a land use regulation that required the mineral rights holders to make certain use of their rights. If the mineral rights remain dormant for more than 20 years, the right will extinguish and revert to the surface owner. The Texaco court found that the regulation was a valid exercise of the state's police powers. The purpose of that police power was to make the entire productive potential of the land available for human use. In response to the Superior Court's use of Texaco, I suggest the following. Number one, it was in fact unlawful state action that led to the loss of the trust's property rights in this case. The town had the authority at all times to properly take the trust land pursuant to Chapter 79, but failed to do so. Second, here the town's unlawful use of the trust land was not pursuant to the exercise of a police power, and nor was it pursuant to a statute that was enacted controlling the trust's use of its land. There is a distinction between a taking and a police power. A taking is a permanent physical occupation of private land for a public benefit, whereas a police powers involve the regulation of private land to prevent a use of the land which would harm the public. There was no public detriment alleged in this case, and in fact, Judge Vey in the land court found the town's invasion of the trust property served a legitimate public purpose. Pursuant to the Triangle Center versus DPW case, a landowner cannot be forced to bear the whole burden of a public benefit without compensation.
I see if you'd brought this claim, right after they started doing it, or even 5 years after, or 10 years after, but when you exceed the prescriptive easement period, don't we get into a whole nother realm, and it's not considered a taking? You've sort of given up the property.
Our argument is that it does in fact constitute a taking.
Well, I know your argument, but it doesn't seem like there's much case law that says that. The cases that I've read, the Alaska case, the First Circuit case, they all seem to treat once that prescriptive easement period passes, you really don't have any rights in the property.
So the cases cited by the town in its brief, which are all out-of-state cases, the majority of those cases...
Well, the First Circuit case is, and it's a Rhode Island case, I guess, right? But
right. And that is a statute of limitations case that is based upon the Rhode Island statute of limitations.
Well, isn't the Rhode Island statute of limitations keyed into the prescriptive easement period the same way ours is?
I would argue that within this Commonwealth that it's different. We've held in our cases in the Commonwealth that the town's prescriptive easement right does not vest until it has been finally adjudicated by a court. So at any point in time prior to the vesting of that prescriptive easement right, the town only has a claim of right. It's not an enforceable right without the judicial adjudication under White versus Hardigan. And so the other element required for the running of a statute of limitations would be notice to the landowner. And in this particular case, the landowner did not have any notice.
Although, I mean, that's the whole point of prescriptive easements. The sort of notorious and open aspect of what the government does provides the notice, right?
Right. The cases cited by the town in its brief all deal with, for the most part, deal with the taking of roadways by adverse possession. And there is no doubt that the installation of a roadway is open and notorious, and the use of that roadway by the public is open and notorious. This is a very different situation where the taking itself was, let's say, obscured.
If a private party were dumping its water all over you, right, you'd have notice under that type of, if it were a private party, the actual dumping of the water would be triggering your awareness of the problem, right? And you would lose, if this were a private entity, you would lose your rights over that property, right?
Right, but this isn't a private entity, this is the government. And the Fifth Amendment and Article 10 both state that the government shall not take land for public purpose without just compensation to the landowner. And that's where I think the distinction lies. Going back to your question relative to the statute of limitations, without notice to the landowner, it's impossible to know when that statute of limitations clock starts. And the Steinberg versus the City of Cambridge case states that the plaintiff could not have brought a claim to enforce its rights until it knew the nature of the taking and the claim of taking became clear. And
Why is this a taking at all? Why isn't it just a prescriptive easement?
it is a prescriptive easement, but the prescriptive easement and the use of the town's, the use of the trust land by the town for wholly for a public benefit is, under the legions of cases that have been decided, constitutes a taking. And easements are compensable. The Nolan versus the California Coastal Commission case identifies that easements should be compensated because they do constitute a taking, no matter how great or small the extent of the easement or the importance or unimportance of the public purpose for which it was taken.
So I'm not sure that it can it be both, because it's an easement. It's the right to use, right?
It is, but the easement is the physical invasion of the property of a permanent nature for a public benefit. I think they're tied together. They are one and the same in this particular case, I would argue.
Is there any case that you have that stands for the proposition that a prescriptive easement by the government is not a taking?
The cases cited by the town in its brief that all come from out of state identify that the roadways that were taken in those particular cases were not takings. They were, in fact, easements, rights to use. Those, again, I would distinguish those because those are very much open, notorious. The road was installed across the person's property.
I appreciate that argument. I do. I'm just asking if there's a case that you've been able to find that said a prescriptive easement that the government's obtained is a taking.
Is a taking? I haven't, and that's why we're here. I'm hoping that you'll say that. And
Can I ask you a question? I don't understand this. There was in the 20 years before it became a prescriptive easement by virtue of the land court judgment, right?
right.
Was the government engaged in a taking in those periods of time? It was using the land inappropriately, you're saying, right?
It was
for the public
using
benefit.
the land unlawfully at that
Unlawfully, right, okay.
Right.
Was that a taking?
time. It's not a taking until...
Wasn't a taking until it became a prescriptive easement?
It's not a taking until the requirements of taking are identified, the notice, the nature of the use, the extent of the easement that's been taken.
It was just an unlawful use. So an unlawful use can't be a taking?
An unlawful use is a taking, Your Honor, under the Fifth
Unlawful use
Amendment.
is a taking.
An unlawful use is a taking.
It was an unlawful use for 20 years.
It was, but there was no notice to the landowner, and therefore the landowner could
There
not
must have been,
protected
otherwise you
it.
couldn't have had a prescriptive easement. declared, right? There had to have been notice.
There was notice to the landowner in 2015. That's the first time the town declared that it was utilizing the trust property for the purpose of a prescriptive easement, and immediately upon receipt of notice, suit was filed.
Okay, thank you.
Thank you very much.
Mr. Lane?
Good afternoon, Your Honors. Tom Lane on behalf of the town of Sturbridge. The case before you is a simple case. We outlined it in our brief, and I don't want to go in circles, but your questions are right on point. A prescriptive easement is not a taking. The case law is clear on that. There's no case.
Is that, if they had brought, I mean, the government doesn't just get to use people's property. I mean, they can't just come over to my land and take it and use it for whatever. They can't just go over and start dumping water on my property and not compensate me. If it's brought within, I mean, if they brought this a year after it started, would that be a taking?
It would not be a taking.
Why not?
It would be a trespass claim. It would be a claim that you were trespassing or a nuisance claim. The Triangle case was right on point. The Triangle case said it's not a taking in pay. This is a nuisance claim, and you need to look at what the nuisance damages were. During that 20-year period, and we have the factual record from the land court, and that decision was never appealed. It was open and notorious for that at least 20-year period.
You get, basically, the way to remedy what you're doing is a nuisance claim or a trespass claim for 20 years. And then if you do it long enough, then there's no nuisance and trespass because you, or is there still a nuisance and trespass case?
There is not. There's a defense to those claims. A prescriptive easement would be a defense to those claims, just as it would be between two
So after
abutting.
20 years, you get a right to do what you're doing because you've been open and notorious about it for 20 years? Is that right?
Exactly, exactly. And the case law is clear with a prescriptive easement, and Judge Wren in the Superior Court determined that it was up to the property owner to challenge what was going on, and they had the right to do that during that
But they never
period.
had a right to say that it was a taking and get compensated for it. At no point, either before or after the prescription, after prescription.
Well, they could make the argument during the 20-year time
But you
period.
just said to me that was a trespass, that was a nuisance, that wasn't a taking.
Well, again, you could file a claim for a trespass or nuisance and ask the court for an injunction to ask them to stop putting the water on there, which could potentially lead to a taking during that time period, but it was never done in this case. And I think it's important with the history, and you have Judge Vay's decision and in the trial that was involved. This was a culvert that went underneath Hall Road going back to the 1930s. He found that the culvert first was going underneath Hall Road during the 1930s. 1987 was the date that he was used because that was the date that the town had actually reconstructed Hall Road as part of the ongoing reconstruction of the ways, and the size of the culvert was actually smaller at that point. And 7 feet of that was smaller in diameter, but 7 feet longer. And 7 feet of that culvert then went on to plaintiff's property. So that's why the 1987 date was being used. And it's important that the court be aware that there was another party in that land court case, DHC, which was the property owner on the other side of the property. This entire area, the water comes off to Fisk Hill. Fisk Hill is a large area, and the court has, Judge Vay has, and as part of your appendix record, is an area that the water drains the town of Sturbridge, has always drained over time, coming across as Hall Road was developed. It came across and would go through the end of the plaintiff's property. When the culvert was installed, it directed some of the water. In 1987, the road was redone. DHC was also granted an easement. Judge Vay granted 3 easements at the time of his decision based off a prescription. One, he granted an easement for the 7 feet of the culvert, because now the culvert was a little bit longer in length and did go on to the plaintiff's property. He also granted an easement to the town for the flow of water. And again, the water is not so much coming from the town's roads, it's coming from above, it's coming down Fisk Hill across DHC's property and channeled again across through the plaintiff's property, and then channeled out the other side of the plaintiff's property under Route 20 to a marshland on the other side of the road. Judge Vay did a site inspection, excuse me? Judge Fay did a site inspection and looked at what was going on there and made those factual findings. And the key is an open and notorious factual findings. Open and notorious requires a 20-year period. It's not a situation that this was hidden under the road that no one could see what was going on. During rainstorms, and the testimony at the land court trial was that during rainstorms, you could physically see a culvert, but you could also see the water flowing through underneath.
Does it make the property undevelopable or unusable?
We've never, again, the town now has, town and DHC now have prescriptive easements. I think that would limit some of the use that the plaintiff could make on their property. I think you'd need expert
But
testimony.
before they had the prescriptive easement, before you acquired the prescriptive easement, did the culvert and the flow of water make this unusable? I understand federal taking law is incredibly complicated, but my understanding was you've got to somehow impact the ability to develop the property, right?
Exactly. And again, I have to concede, because it does traverse the plaintiff's property, that it likely would have some effect on the value of the plaintiff's property if there was not a prescriptive easement. If this was a situation that the town just decided to start, as you mentioned, started immediately dumping water on it.
Does that make it a taking if it has a percentage, it lowers the percentage value, that necessarily makes it a taking? It could make it a taking?
It does not make it
I mean,
necessary.
if they'd done a formal taking, I understand that. Right.
Yes, they would have to do a formal taking, or even a taking and pay. They would need some statutory authority to do something such as that. That was never done in this situation. It was a situation, again, where it was a prescriptive easement granted, and a prescriptive easement is just not a taking. It's a different theory, and Judge Wren correctly pointed out that it's by the plaintiff's inaction and not challenging the water coming onto the property or filing a trespass claim or doing anything over that 30-year period while it was open and notorious that created the prescriptive easement for the town.
So you're saying that Judge Wren was correct in his ultimate ruling, but wrong in saying that they could have brought a taking claim earlier?
No, well, I think Judge Wren said that if they had filed the claim within that 20-year period, they could have, I believe he used the word, they could have filed a claim. It may not have been a taking claim, it might have been a trespass claim, it might have been a nuisance claim. If it reached the point of being a taking, I still don't think it would have been a taking, because you didn't have the triangle case where it was not a taking and pay. They directed everyone to a nuisance claim or what was involved. Oftentimes, to control a nuisance type claim, you might then move to do a formal taking to do what was involved there. Thank you. We would request on behalf of the town, again, and then just to mention that it's important for the town's perspective and other towns' perspectives that you have drainage concerns throughout the Commonwealth with roadways going back and culverts going underneath roads going back hundreds of years, and this is somewhat important to the town. We request that you affirm Judge Wren's decision. Thank you very much.